Speaker, and thank you to the members who have contributed to a very thought-provoking debate this afternoon. I would like to reply, if I may, Madam Deputy Speaker, to some of the points which have been raised, starting with the first question raised by the Shadow Minister, the member for St Helens North, on a lone actor review, I think new clause number 8. I know he's had what I hope was a lengthy and fruitful conversation with the Security Minister earlier on today, and of course he will be aware that the Prevent review that we've just been talking about will touch on this, but also the MAPA review will also significantly engage with this topic. I have been endeavouring to obtain a firm date for publication in the course of the last few minutes. I'm afraid the best I can do from this dispatch box at the moment is to say that it will be soon. It will be as soon as practical. I hope it'll be within the sort of time frame he was asking for, but I'm afraid I can't give him a precise date. But it is imminent, and we'll do it as soon as we possibly can. And I believe that MAPA review will contain many of the issues the Shadow Minister has been raising in relation to the lone actor threat that he and his colleagues have been discussing. Let me turn now, Madam Deputy Speaker, to the substantive questions about TPIMs, which arose both this afternoon and in Bill Committee. And let me start with what the Honourable Member for Edinburgh South West termed as the business case or the operational case. Why is it that we're proposing to lower the burden of proof? The member for St Helens North, St Albans and Bromley and Chislehurst raised the same question. And the best answer I can give the House to that question, what is the business case for changing the burden of proof, is the evidence given to the Bill Committee by Assistant Chief Constable Tim Jake, one of the national counter-terrorism policing leads, who had been briefed by the security services prior to giving his evidence. And he gave us in his evidence, available in Hansard, 3 reasons why a lower burden of proof, a reasonable suspicion, might be, it would be better, would protect the public. The first reason he gave is that where an individual's risk profile is rapidly increasing, there may not be time to establish the higher burden of proof before a threat or a risk materialises. Secondly, he said that where somebody is returning from abroad, for example from Syria, it is very hard to establish an evidential base to the balance of probability that someone has been involved in terror-related activity, because by definition, getting evidence from somewhere like Syria is very hard, if not impossible. And the third reason he gave was where sensitive material needs to be relied upon. Disclosing that material to get you to the balance of probability would potentially endanger sources, confidential sources. It is clearly easier to get to the reasonable suspicion standard without disclosing that material. So those are the 3 reasons that he gave. Now, I accept, just to preempt the intervention that I sense is brewing, it is true that historically, looking back, there has not been an occasion on which the security services wanted to give a TPIM but could not because of the burden of proof. There is no such historical example. I freely concede the point. I suspect that was the topic of the intervention, sort of. However, as my honourable friend, I think, said in an intervention, we have to deal in this House not just with what has happened in the past, but with what might happen in the future. And we have been very clearly advised by Assistant Chief Constable Jakes, and through him by the security services, that this is something which is necessary to protect the public. And I asked him in question 50 on column 21 of his evidence on the 25th of June this year, asked him explicitly, would this lower standard of proof make the public safer? And he answered categorically, yes, it would.
I mean, he anticipates my objection, because could I also refer him to what he said in response to me at question 58, column 23 of the official report for 25th June. I said, where there is a rapidly escalating situation or where there is a need to manage sensitive material, we already have available to us the option of a new variant TPIM without changing the standard of proof. And he replied, well, a TPIM is a TPIM. We have the option of a TPIM to manage that case. Yes, as it currently stands, MI5 has pointed out there is no case thus far where the standard of proof has been a blocker.
Well, as I said, I accept that. I accept that there has not been any historic cases where the standard of proof has been a blocker, but we have been advised categorically by the security services, speaking through Assistant Chief Constable Jake, that it might occur, and that, I beg your pardon, and the proposals we are making here will make the public safer. He said that categorically, and I do not think this House could or should disregard such clear advice. In relation to Jonathan Hall's comments, I suspect that Jonathan Hall may not have heard the evidence that I just read out, because Jonathan Hall gave his evidence to the committee immediately prior to Assistant Chief Constable Jake's. And the evidence he gave was new evidence, new to the House, new to Parliament. We didn't have that evidence, for example, at second reading, but we do have it now, and I think we should have careful regard to it. Now, a number of members have raised questions about civil liberties and not wishing to intrude upon an individual's freedom. I'd like to directly address those questions now. I'd like to do so with reference to the original 2011 TPIM Act, which I have here, because by lowering the burden of proof, we're only changing one of 5 limbs. The other 4 limbs remain exactly as they are, and one of those, laid out in Schedule 3 of that bill, is that the Secretary of State must reasonably consider the TPIM is necessary. I use that word necessary very carefully. It's necessary for purposes connected with protecting members of the public. And in subsection 4, condition D, it goes on, it is necessary for purposes connected with preventing or restricting the individual's involvement in terrorism activity. So there is a test here of necessity that goes far beyond simply the reasonable suspicion referred to in the first limb. So that requirement for necessity is unchanged. Now, the member for St Albans, in her remarks, said that this could be given out on a minister's whim. A minister, by a sweep of the pen, could impose a TPIM. But in fact, I have to say to her, just very gently, that is not the case. There are judicial safeguards in the 2011 Act here. So in Section 6 of that Act, when a TPIM notice is given, the Secretary of State has to go to the court and make an application, and the court has to verify or validate that the TPIM is a reasonable TPIM. It has to certify that it is not obviously flawed. That is the phrase that is used. So there is judicial certification. And moreover, Section 16 of this Act, the 2011 Act, provides for an appeal right. So if the subject of a TPIM feels they've been unfairly treated, if they feel the TPIM is unjustified, they can apply to the court on a process akin to a judicial review, and they can apply to have that TPIM overturned. So there are judicial safeguards to protect individuals from unreasonable actions by the government. But I am pleased to say, Madam Deputy Speaker, in the many years that TPIMs have been in operation, since 2011, and indeed in the 6 years that control orders were in place before them, since 2005, the numbers used have been very small. There were never more than about 15 to 20 control orders in force at any one time, and we heard evidence that as of today there are only 6 TPIMs in force. It's a very, very small number, used only in exceptional circumstances. And when I asked Jonathan Hall in evidence, did he believe that any government, the previous Labour government or the more recent Conservative government, had ever abused the power provided by TPIMs or before them control orders, he answered no. He was not aware of any such abuse. And I would add that a former reviewer of terror legislation, Lord Carlisle, has expressed support for the measures in this bill. Let me turn now, Madam Deputy Speaker, to the question of time, the extendability of TPIM. So they currently expire after 2 years. We propose to make them extendable in 1-year increments, as the old control orders passed by the then Labour government, and indeed supported by some members in this House this afternoon, were as well. And we heard evidence from Jonathan Hall, again, to say that there was a risk where a TPIM ended after 2 years, there could be a gap. And he knew of 2 cases, 2 real cases, where there was a gap in one case of a year and in a second case 16 months before a new TPIM could be obtained. And that's because you have to get fresh evidence. You can't rely on the old evidence. You've got to wait for somebody to do something wrong again to give you the grounds to renew the TPIM. And Max Hill, when he was independent reviewer in 2017, said that some people, some terrorists, bided their time in order to wait for the TPIM to simply time out. And again, I say with reference back to the previous control orders from the last Labour government, in fairness to that government, even though they could be extended year by year, in practice most of them weren't. 30 of them were for less than 2 years, 8 were between 2 and 3 years, 4 of them were 3 to 4 years, and only 3 of them extended for between 4 and 5 years. And again, the subject can apply for judicial review if they think the TPIM extension is unfair. So there's judicial protection. 2 very, very quick final points. In terms of prosecution, which the member for Bromley-Shislehurst asked about, there is a duty under Section 10 of the 2011 Act that requires the Secretary of State to seek prosecution where appropriate. And on prevent, look, the statutory obligation to do the prevent review remains. There have been some delays because the chairman had to be replaced, then there was the coronavirus pandemic. Our commitment to do it remains in statute. Specifying a date obviously caused a problem before. We don't want to repeat that mistake. We hope and expect it will be done by August of next year, but we feel, given the experience of the recent past, putting that date on the face of the bill would simply be setting a bear trap. So I hope, Madam Deputy Speaker, I've laid out the case for resisting these amendments this afternoon in this report stage.
Shadow Security Minister Conor McGinn.
Thank you, Madam Deputy Speaker. And in the brief time available, I want to firstly thank the Minister for addressing some of the concerns that we have raised, not just today at report, but I think through what was a very thorough examination of the bill at committee stage. It's fair to say that while we on these benches wholeheartedly support